Well, recording in progress. Got it.
Right.
Well, thank you everybody for being here. I appreciate your time. Let me go ahead and share my screen if I can. Oops. Slideshow. Great. Can you see my screen? Great.
Yeah.
So I'd like to spend some time talking a little bit about cybercrime, kind of discuss what we were just talking about with hackers and ransomware and malware. It seems to be a very hot topic, but when I started to dive into it, I started to see that this is very complicated in actually being successful in getting criminal prosecutions out of it. So I started taking a look and I started seeing a lot of startling statistics. And actually, while this says that for everyone that gets caught, 10,000 go free, I've seen that number actually go up to even 100,000 go free, maybe more. And in fact, the vast majority of cyber crimes are never reported. And when I'm saying cyber crimes, essentially we're talking about hacking or installing malware on protected computers, computer intrusion, identity theft, stealing usernames and passwords, things like that. And what I really found was that, particularly in the United States, only 3 in 1,000 malicious cyber incidents will actually even see an arrest. And when I did some research in the EU, and I noticed from the Budapest Convention on Cybercrime, they indicated that really the powers of law enforcement are limited by territorial boundaries. So as a result, really only a very small share of cybercrime is reported to criminal justice authorities. And there are actually very few court decisions on this, which really surprises me based on the amount we know of hacking and stealing of username and passwords out there. So I asked myself, why? Why is this so difficult to prosecute? And I found 6 key factors. The first being attribution. It's very difficult to find who exactly is hacking your computer, unless, like Vashko, you hire them to go into your computer. But a lot of times they use proxy servers and you don't even know who exactly was the one who did the hacking. The other thing that I found makes it incredibly difficult to criminally prosecute these is a lot of them can be state actors, Russia and China in particular. So of course, if these are state actors that are doing the hacking, you're going to have a hard time criminally prosecuting and extraditing them because jurisdiction is obviously a problem. I also found that apparently those that are born at 1999 and previous to 1999 were called the people from the 1900s. And so apparently what we find are the people that are from 2000 that were born 2000 and up to today are considered much more savvy for computers and knowing how to hack than those of us that were born in the 1900s. And what I found was when I started to look at research of transnational groups of hackers, I found that Lapsus was one of the big groups. They were based mainly in the United Kingdom and in Brazil. And they were found to do significant hacking. In fact, in the UK, they were prosecuted, but a lot of them are juvenile offenders. Many of the high-profile arrests in the UK involved these juvenile members. And for example, the City of London police arrested 7 juveniles in relation to the Lapsus group. Shortly after the arrests, Lapsus then announced online that it was back from vacation, posting a screenshot of additional data and administrator credentials that they had infiltrated as soon as they got back from their arrest. So this is a problem because this calls into question whatever kind of level of disruption and impact that we can see, particularly in the juvenile justice system. Number 3, there is no such thing as the internet police. So we really have to rely on international cooperation. You can only imagine how difficult that could be. The Budapest Convention on Cybercrime, they've been trying to do a good job. They criminalize conduct ranging from illegal access, data and systems interference to computer-related fraud and child pornography. They have procedural powers to investigate cybercrime, and they have tried to create some sort of efficient international cooperation. So I think what we've seen is this is a very good starting point, right? Because the convention provides a legal framework for international cooperation. It provides some tools for enhanced cooperation and disclosure of electronic evidence. The members of this cybercrime convention committee share information and experience. And like I said, they do engage each other in trusted and efficient cooperation. But that only goes so far. Number 4, understanding computer forensics is difficult, right? How many of us really understand how they are able to install malware and hack into our computers and steal these usernames and passwords? In fact, what I've found is that I think there was in Ireland, some hackers used an employee's infected computer to break into Ireland's public health system and tunnel through the network for weeks. And then they spread the infection to thousands of other computers and servers, and they made a ransom demand after they hijacked about 80% of the IT system. So that forced the hospital, over 100,000 people, go offline and really jeopardized the lives of thousands of patients. What we're finding is that these companies can no longer rely on any kind of government cooperation in criminal prosecutions, because we have companies such as Microsoft that indicate that hackers are using tools like Cobalt Strike which was basically designed to simulate cyber attacks and defense testing. And they use these tools like Cobalt Strike to steal and manipulate older versions to launch these ransomware attacks around the world. So these companies, like Microsoft has a digital crimes unit and a malware analysis and disruption team, because we're finding it's so difficult for the government to identify these hackers and criminally prosecute. The other thing too is understanding cybercrime laws are difficult. I'm going to go through a couple of them now, but they're intense. This isn't just a simple analysis of a homicide or a simple theft. So I think that can kind of throw prosecutors if they are not familiar with cybercrime laws. And presenting IT evidence in the courtroom, particularly in the United States in a jury trial, is very difficult. And I'm going to talk about that a little bit later. So what I wanted to kind of decide, I thought I would do to make it a little more interesting, rather than me just talk about cybercrime in a vacuum, I wanted to share with you a successful cybercrime trial where they were able to successfully prosecute a hacker. This is very rare. It took me a while to try to find an actual cybercrime trial in which the prosecutors were able to identify the hacker and criminally prosecute. So this is Yevgeny Nikulin. Now, Yevgeny was 32, and he was said to have hacked into computers belonging to LinkedIn, Dropbox, and Formspring. And he damaged the computers belonging to LinkedIn and Formspring by installing malware on them, he stole and used the login credentials from employees, and then sold and conspired with others to sell the customer data he stole as a result of his hacks. Now, the evidence at trial showed that Nikulin was located in Moscow when he hacked into a computer belonging to a San Francisco Bay Area-based LinkedIn employee and installed malicious software on it, allowing him to control the computer remotely and to use the employee's credentials to access LinkedIn's corporate VPN. So once he had access to these corporate systems, Nakulin stole a database containing LinkedIn users' login information, including encrypted passwords. And then he was behind similar intrusions and thefts of data at Dropbox and FormSpring. So he basically was arrested while traveling in the Czech Republic, because obviously Russia wasn't going to extradite him. So he made the mistake of traveling to the Czech Republic, and then he was extradited to the United States to face trial. So what was he prosecuted for? He was prosecuted for, here we have conspiracy charges, 18 USC 1029E2, installing, selling stolen usernames and passwords, 1030A5, installing malware on protected computers, and 18 USC 1030A2C, computer intrusion, and then 1028A1 is aggravated identity theft. So just briefly, just so you can kind of take a look here, these are somewhat complicated cybercrimes. 1029A, you really have to prove that the defendant knowingly trafficked in unauthorized access devices. So basically, he stole credentials. He had to obtain something of value worth $1,000 or more. He had to have the intent to defraud, and the defendant's conduct affected interstate commerce. In 1030, essentially, this is fraud, and this was a fraud in relationship to when he put this malicious software that they called Madness on the LinkedIn's employees' iMac. 1030, intentionally accessing a computer without authorization, is very similar to 1029A. And then aggravated identity theft, this is when he impersonated the LinkedIn employee using a means of identity without authority, knowing this means of ID belonged to a real person. And he did so during the violation of this hack at 18 USC 1030. And just to show you, these are different countries, which have a lot of countries that I was doing a comparative law analysis on have very similar types of cybercrimes. Here is Poland's, obtaining access to information not intended for him. I noticed that the years of imprisonment are a little bit less than in the United States. Here it's 2 years. I found actually the one in Indonesia, where again, it's knowingly without authority accessing computers, carrying out interception of electronic information, interception of non-public electronic information. And here we have penalties of 6 years to 10 years, which is a little bit more in range with the United States. So what happened in this trial? Well, first what we see is the prosecution's opening statement was pretty interesting. Essentially, what the prosecutor was saying is, look, you're going to hear a lot of lingo as far as computer lingo. You're going to hear about these virtual private networks, hashing algorithms, databases, servers. But really, this is a case about stealing, plain, ordinary, run-of-the-mill theft. So she wanted to make sure the prosecution could educate the jury to say, look, we're going to teach you a little bit about computer forensics, and we're going to present some IT evidence, but in reality, this is just simple theft. Well, the judge in this case, I found really interesting, because he immediately, as the case was going on, is like, look, this case is, quote, boring city. He told the prosecutor, and really that's all I'm going to say about that now. The other thing I want to say is we have 2 jurors who are on the verge of going to sleep. This is very boring. To you it might be exciting, but they're doing the best they can to stay awake. So it took a long time to make very simple points. So could you please pick up the pace? So the first difficulty that any kind of prosecutor is going to have is to get over the hump of boring everybody to death. What was the defense's cross-examination? Well, obviously, the defendant is going to have to challenge the computer forensics, and it's going to have to confuse the jury to show that his client, the defendant, wasn't in fact the hacker. So the first thing I noticed that the defense attorney did in cross-examination was to say, look, you know, IP addresses can't definitely tell you who did the hacking or even where the information was sent from, right? As you see here on the question, as he was questioning the government witness, look, if you go to Starbucks, for example, strangers in the cafe all use the same IP address, don't they? Yes. So you wouldn't be able to tell who the hacker was at the Starbucks. And then he gets into the proxy servers, right? A proxy server is one where the IP address that's transmitted to your end is not the actual IP address where the information was sent from, right? Correct. So again, he's identifying that this IP address isn't necessarily a slam dunk to prove that his client was the one who did it. The prosecution, time and time again in this trial, they repeatedly had to justify why they were getting in the weeds with this IT for computer forensic technology, because they were arguing that this was just really confusing IT evidence. But the bottom line is the prosecution has to prove that he was actually the hacker. So every time the judge is pushing in the trial, like, look, why do we have to go into all this excruciating detail that seems irrelevant? I mean, is there going to be some magic witness at the end that ties it all together? I mean, it's really hard to pay attention to all this, and it's hard to understand why it matters. So the prosecution throughout this 6-day trial had to keep explaining to the judge why the IP address matters, why we have to get past the hump that the proxy server can mask this. What's a browser cookie? Why do we care about user agent string? But these all were data points to identify the attacker and the emails used to, reveal the hacker. So anyway, the prosecution felt like they were losing people, like I'm probably losing people right now. So the judge pushes back because now the prosecution went ahead and said, well, let's go ahead and use the jailhouse calls that the defendant was calling back home to Russia while he was waiting for his trial. And so the judge pushes back even on the relevance of these jailhouse calls, because in these calls, he demonstrates that he's interested in high-tech computers and girls. And the judge says, well, I don't understand, like, why do you possibly want to put in these calls other than to prejudice the defendant? Because the judge says there's about 1 billion people on earth who happen to be interested in high techs and computers, and for that matter, girls. And to me, if that's evidence of guilt, then God help us in this country. That's terrible. So the prosecution has to explain, I hacked 24/7 was one of the calls that the defendant made on the phone while he was in jail. And the judge admits that's good evidence that he has a propensity to hack. But again, he's pushing back to say he doesn't think that these types of jailhouse calls are going to help them. And he says, I don't see a lot of evidence that this particular defendant is the one that did it. Though maybe the scales will fall from my eyes when I hear your brilliant summation. So we keep going, and the biggest, most important government witness in this case was FBI agent Miller. He essentially was trying to put all the evidence together to explain how we can prove that Nikulin was in fact the hacker in this case. And so the defense attorney in this case, he decided that he was going to focus, the defense attorney, Adam Gassner, was going to focus on the fact that perhaps they were using Nikulin as the scapegoat, that in fact it was a Russian state actor who was the true hacker. So they wanted the jury to think that we can't trust international cooperation with Russia. So he asks on cross-examination, you got to rely somewhat on the Russian government to cooperate with you, correct? Yes, I did. And as you stated, that you didn't have an independent way here in the United States of obtaining the IP addresses that originated in Russia through legal means here. And at worst, it was misinformation, right? And the agent said, I have no reason to doubt the information returned to me from an MLAT. It's an official treaty, so all information I receive back is genuine. And the defense attorney says, you're not skeptical of information that you received from the Russian government? No, not in response to an MLAT. Really? As a member of the American intelligence community and with the information you have and the background and education you've received, are you saying you don't have skepticism on that? I'm saying I trust that the information that they provide is accurate. And if I can prove otherwise through other means, then that is a different story. So the point is we aren't able to make an independent inquiry as far as whether the IP address that the Russians provided us was in fact genuine. And that IP address was very important in identifying that Nukulin was the one behind the hacking, at least in LinkedIn. The defense attorney was also able to argue in cross-examination that the email linked to the hacker in the Dropbox computer intrusion was of the name China Big, was the email. And they found that the subscriber information to this email was a man named Alex Corti. And the actual language code associated with that email was DE, which, I don't know, Dimitrios, I believe I've been told that's the German language code. Am I right? Okay.
Right.
Okay. So that means that a Russian hacker, I mean, it's possible he would create an email to throw them off called China Big and then use a German language code instead of a Russian language code. But it's great fodder for the defense attorney to say this information doesn't add up to a Russian hacker. So he finishes his grand finale. I've finished a 6-day trial, and hopefully I haven't talked more than 10, 15 minutes, but he uses his grand finale of his defense closing to make this argument that we should expect better evidence, better quality evidence. Send that message to the government with your not guilty vote. No matter what's in the news, no matter what language the defendant speaks, no matter what his name is, in the United States federal courthouse, you deserve, and most importantly, Mr. Nukulin deserves to be judged not by his nationality, but on good quality, clear, and uncontradicted evidence. And why did the Russian government provide misinformation to the United States? Well, perhaps allowing a real culprit to be caught and tried in the US would lead to a lot of revelations that the Russians did not want us to know. And then he pointed out that proxy servers can be used to mask IP addresses. And lastly, the prosecution, of course, gets the last word in front of the jury. And essentially there, we've decided, after all that you've heard from this trial, really identity is the big issue in these hacking cases. And the prosecution asks us to follow the trail of digital breadcrumbs, right? If in fact the account that hacks Dropbox is this China Big, and it's responsible for all 3 hacks, they were able to connect that email with a separate email, root Talka, that was found, could be found, it was a VK on Russian Facebook that created, that was linked to the same IP address as the one of China Big. And if that IP address is LinkedIn's, associated with the LinkedIn hack, and per the MLAT, that IP address goes back to Nukulin, then we can say those 2 email addresses are now controlled by Nukulin, and Nukulin is the hacker. And that was its final response to all this, how they were able to track who the true identity of the hacker. Well, in the United States here, we see that the max amount they could receive for one of these crimes was 1028A, aggravated identity theft, was 10 years. Nakulan was actually found guilty after the jury deliberated, and he was actually sentenced to 88 months. And he had actually been in prison in the United States almost that much because of COVID and everything. His trial had been delayed. And so he received the 88-month sentence and didn't actually have to spend much more time in jail. So I would just say that in conclusion, as I was analyzing these cybercrime cases, I found that we need to brainstorm more on this issue. We talk a lot about cybercrime, but I don't think that I think we need to be looking at, I personally believe this is good for an LP's topic, because I have noticed here the importance of international cooperation. I think that cybercrime goes beyond any kind of jurisdictional boundary. And I think that we do need to look at this at an international level with international coordination. And I think we need to be brainstorming more, even as law professors, to see how we can assist in these cases, because they are incredibly difficult, first to identify, second to prosecute. And there's a very difficulty in extradition and MLAT treaties and things like that. So I think we need to be brainstorming more, because this is only going to be solved if we do this through international coordination. And I'd like to see the Budapest Convention to be reevaluated to see how it best could be improved. How'd I do? One, that's not too bad. 37 minutes, 30 minutes or so. I didn't want to go too much longer because this can be boring.
No, it's not boring. It's really interesting. And by the way, we have a case here in Portugal that was judged 2 months ago of a guy named Rui Pinto. There was a well-known hacker that published documents that were hidden about the football leagues, corruption in football, and the other league he participated to was not about football, but about corruption in somewhere in an island, well, where he found some problems. And apart from what you said, which is really correct and happens here with us, when I say that in this case, the European cooperation worked. He was living in Bulgaria, and he was caught, and he was returned to Portugal. But then he went to trial. He was in prison, but he went to trial, and he confessed and cooperated with justice. So the result was that he was convicted for 4 years, but with the suspension of the penalty. So he got probation. He's outside, still complaining and appealing the decision of the judge, but it stayed the same as he had to pay something because of the blackmail. It tried to blackmail a lawyers association and other entities and some football clubs, but in the end they consider there was public interest because he helped to solve other problems, told about the ways the hackers do, and the situation ended in a very typical Portuguese way of, well, he's a good guy, and probably he is. I'm sure his mother loved him, but
how did they identify it was him who had done the?
He made a mistake when the documents of football leagues were published. He said, I was responsible. He thought he could not be caught because of that and could not be punished. But at the time, the Portuguese police contacted the other polices where he have been. By the way, the first time he has been away was in Erasmus stay in Mockery, and then he decided to stay afterwards for his criminal life because it was better than coming back to Portugal. And from that point of view, the things worked.
So was he extradited? Did he have to be extradited, or did they wait till?
Yes, it was extradited. There's a European cooperation among policies, the Interpol, and that is more than Europe, but there's also some specific rules for European countries, and the things work quite well. But the result in the end, we cannot say that it was so good. But so it's another problem, the problem of the difficulty there is to get a conviction, because the people don't think it's really a crime, especially when well, they discovered other things and so on. It's hard to be considered guilty in these situations. It happened also with crimes against the environment. In Portugal, nobody that I know until now was convicted, and we have a penal law for protecting the environment for more than 40 years. We were at the time a kind of pioneers in Europe, but nobody until now was ever got to the court. Wow. And no conviction at all. So it's also a question of the idea that people have that's not really a crime like the others. It's a bad behavior, but better to understand. Well, which is rather strange, let us say.
Which surprises me, because I would think, who hasn't gotten their identity stolen online? You would think that they would connect with that and understand how dangerous this is to have these hackers out there that are stealing, all your private information. You would think that there would be more outrage and people would understand that this truly is a crime. It just surprises me.
Well, I don't know what we should do for that, but we should do. It's a cultural problem.
I mean, the same thing with climate change and all the environmental issues now.
It
I mean, but it's shocking.
But it happens in all Europe. And as far as I know, even in the States, there's a crime, but there's no convictions, and people is not going to the court. So why? Because probably there is not the general idea that there is the real crime. That's a special crime. In the environmental cases, the only things that work are money penalties. Yeah, they work because they come from an administrative body, and the people has to pay. Otherwise, they'll go to court because they did not pay. So that works. But to be convicted by an environmental crime, a crime against the environment, as far as I know, in Portugal, it never happened.
Wow. Did the trial of this guy, was he found guilty, and then afterwards he confessed?
Yeah, confessed everything, cooperate with the judges. I don't know what he done, but he said there was a good cooperation, was public interest about the things he revealed. So in the end, he got very good lawyers, also support from a political party. So in the end, everything turned on well. The other situation I told in the beginning, just not to have confusions, I recurred to an enterprise of digital consultants. But I must say that I did that because a lawyer that I know said we had problems with our law firm, and they solved in a situation that is close to that. So that's why I did, and they recovered all the material I had that was apparently destroyed, but it was hidden in the computer. So that's my story.
I,
Nothing. I didn't contract no no hacker. I didn't know nothing about it. But well, as a joke, it had to be a hacker.
well, I almost think it's going to take a hacker to find a hacker, like these sophisticated hackers that are just devastating these companies, and stealing their clients' information. I mean, this is just devastating to
Yeah,
companies.
indeed.
But it's so sophisticated that I think we're going to need, I almost think we need to like get some of these hackers, prosecute some of these hackers, and then do exactly what you said, get them to cooperate to help us solve some of these hacking problems, or else it's just going to keep happening. I don't know.
Yeah.
Demetrios, what do you think?
I'm actually terrified by the whole topic. To be honest, it's a complete how to say. I do not consider myself a specialist of cyber elements and stuff, and I'm aware of the fact that cyber crimes exist in all our legal orders present here, and they are quite harshly punished. But the cases seem to be quite how to how to say. I'm so terrified I can't even depict what I mean. So, but maybe, yeah.
No, they're limited. I really had to do some research to try to find some sort of actual even trial. So I'm gonna look up the one that Vashko mentioned, because I'd love to look into more about his trial, because they're so few and far between, and I'd love to do a comparative study to see what they look like. I wonder if there's like a transcript of that trial, because I thought that this would be a slam dunk as soon as they extradited this defendant, but it clearly was not. It clearly, I think kind of what Vashko mentioned, it's difficult to convince people that it's a crime, or that it's even that we can trust the computer forensics to suggest that this person actually did commit the crime, because everybody's kind of, like you said, Demetrius, kind of scared of these things. We don't really know anything about cyber attacks. And I think we're going to have to get more private industry involved, because I don't think that the government has, I mean, as much as they maybe have some in the intelligence agencies, but I don't think we have enough state actors that are dedicated to this that could solve this problem. Other than, of course, I guess Russia and China, that have buildings full of people that do this on a daily basis. But it is kind of scary, and I think we do need to talk more about it. But I appreciate you guys letting me take the time to discuss it here today.
Yeah, it's very good.
Especially
it's
since
something that we like to do. Don't worry.
Well, I mean, I think we should be doing more comparative studies on things like this. I think because I think we could learn from each other, and I think even prosecutors need to learn more about these types of trials comparatively, to see if there's a little more of a connection or a way to educate people more on it, to take it more seriously. So
yeah, you're right. Well, our students don't have any questions to do. Joanna, are you there? João? Well,
I think
they are
there's one
probably.
question. Oh, one hand is raised.
Oh, Salmão. Oh, great. Go ahead, please.
Hi, and good evening to all of the participants.
Yes.
And thank you to Professor Vasco Pereira da Silva for this opportunity to listen our professors and share some ideas with the Professor Melanie Reid and the Professor Dimitrios Parashu. Well, first question I would like to put to Professor Melanie, because in the beginning I have preoccupied, but now I'm terrified. Well, the cybercrimes now is normally, and the internet shows to all how is big the places can do the cybercrimes. And my question is to, when to join internet with the artificial intelligence and the technology metaverse, what can control these three factors joined? Because you haven't no one law to control the internet. It is possible, this is the first question to put to the Professor Melanie. It is possible to make one good law to control the internet. It is possible. And the second question is, the rules in all the countries like China, like Russia and Europe and the countries of Oceania, it can join one law, digital law, to don't interfere the states to control the traffic of the internet about the cybercrimes. Because unfortunately, the cybercrimes will be the future, not our generation, but the other generations, because you see, you saw the kids with PCs make all the things you can possible, imagine possible. And in the future for them, it must difficult, because with the three forces joints, metaverse and EA and the internet joint, will be a big, not taste, but finally to think how can control it that, and how can the law punish the guys. Sorry about my English. I'm the simple as I can, and thank you for listening.
No problem. I appreciate the question, and it's such a great question. I mean, the biggest problem I see with, prosecuting cybercrime in particular is jurisdiction, jurisdiction, jurisdiction. And what you are suggesting, creating this one code law, one digital law that can be applied internationally, is a great idea, but I unfortunately don't see that ever happening, because I think that the different players have different thoughts on that. You'll never convince Russia and China to have, they may say they have these types of laws on the books, but if you have state actors that are actually doing the hacking, they're never going to join onto this. And I think that I think the best we could do is build off the Budapest Convention on Cybercrime and things like that, and try to get members to sign some sort of universal, digital law, as you referred to. But I don't see that in the long term. I don't see that happening. And I think what we're going to see is, you're absolutely right. The problem is prosecuting these, because usually the hackers are from a different country. And when you mention something like the metaverse, same exact thing. I mean, they say that in the future, these younger generations aren't going to go out to the bars and have a drink with their friends. They're going to say to their parents, I'll see you later. It's Friday night. I'm going to go back into my room and put on a VR headset and go to the metaverse and hang out with my friends in a virtual bar. Who has the jurisdiction if something goes wrong in that virtual reality? Who is going to prosecute that? I don't know. And if somebody feels like they're being sexually assaulted in the virtual world, under which definition of sexual assault does that apply? I don't know. If somebody steals your, your property in the metaverse, who prosecutes that? I mean, you're going to have to then go back into the real world and try to file either a civil lawsuit or a criminal prosecution here in the United States for somebody who potentially is, across the globe. These are real difficult, issues that have not been resolved. And I see it coming in the future, or they're here now. And we're really scrambling because we don't have a virtual court or some sort of digital laws that you're referring to. And I don't see that. I see it more and more relevant as the younger generations, are basically living in a world dictated by AI, the metaverse, and the internet. And I made the joke that there is no such thing as the internet police, but maybe we do need to be rethinking this, because it's not going away and there is no code of conduct. We're just kind of piecing it together jurisdiction by jurisdiction, and then not even able to access the person that actually is the perpetrator. So I'm sorry, Solomeo, I really don't have an answer to that. It's more of a throwing it back out as far as, this is the next generation has to really be thinking about this issue and trying to figure out, can we build upon the Budapest Convention and other conventions and take a look at this on an international level.
You see also, if I may, because it's a really contemporary thing, and Senor Caridad, your question was indeed to the point. You see how the European Union struggles these days to find an answer for the advised Artificial Intelligence Act. So these days, the Council and the Parliament are trying to find a solution desperately. So it's obviously very, very difficult to find a common denominator. So for a legal framework, which would be necessary. I'm not sure what Paulo Coelho and Karl Kraus would say, as in one of the V-Review articles was talked about by one of the contributors.
This is a private joke for the ones who have read number 7 of our volume of Help is View or Review, because the article of Demetrius is about Paulo Coelho, a well-known Brazilian writer. And very good. You students, you should hear, should listen to what says Professor Demetrius in that wonderful article. Is that when the governments and the parliaments try to react, they overreact. We have now, it was yesterday, a declaration of the Constitutional Court of the inconstitutionality of a law that deals with metaverse data. And the court was right, because as a matter of fact, the idea of control was so hard that indeed it violates some fundamental rights. So it's difficult to find the balance in the things. But I don't think having just ethical rules and these kind of things are a solution. We have to try to have flexible laws, enoughly balanced in order to solve with it. Because if we look at it in a hard way, as did our parliament, the Constitutional Court said very well that it is unconstitutional. So, well, that's something different in a comparative way between the American way and the European. We try to do a law, and we try to have measures to fight against things on a national and even on a European level. But sometimes they are also excessive, so they don't work either.
You're much more proactive. We're much more reactive.
Yeah.
Unfortunately.
But we have to combine both things. Try to stay in the middle in these two different way of doing.
I agree. Well, thank you. This has been great, and thank you for your thoughts on this, because I'm going to go look up Rui Pinto after we close today, because I appreciate the comparative aspect, and I always enjoy coming to these lectures and being part of it. So I want to thank you.
And if you need anything in Portuguese, I can send it to you. You can try afterwards use artificial intelligence to understand, because our newspapers gave lots of news about the case. There's been an important topic. Now we had the dismission of the government that happened today, and the dissolution of the parliament that will happen 2 weeks from now. So everybody thinks about other things. But in the last weeks, the topic was Rui Pinto. One of the topics was
wow. Do they ever publicize or show transcripts of the trial and the discussions with the judge? Is that always private?
The result can be published, and in some courts it's published and it is in the internet. But in this case, in the first level, I don't think it's public yet. But and now there is an appeal. He made an appeal, or I don't know if he did it already, or he just threatened to appeal. It still has time to do it.
The good news is usually if they're appealing, at least in the United States, we have the transcript of the lower court.
To
go up. So maybe they will eventually publicize it.
Yeah.
Publish it. That would be good.
In the end, it will happen. In this moment, I'm not sure. But in the end, of course, if he appeals and the Supreme Court says anything, then you look at the site of the Supreme Court and you have all the sentences, and they are translated in English. English, it depends on the court, but Supreme Court in English. If it is Constitutional Court, English, French, and Spanish, we have that tradition of having, like in Germany, the German court publishes everything in all the languages. We can choose, no matter what European language you talk about, you can do it.
Right.
But well, it's the opposite. It's us that need to thank you. It was a wonderful lecture. Indeed, the team is wonderful. It was very well explained, and it's a bright mind that is behind the thoughts you brought to us, and we learned a lot with your lecture. So
I wanted to keep going with our theme of AI and cyber.
Yeah, you should. You should.
Well, thank you all so much. I appreciate it. It was great to see you. And if I don't see you before, happy holidays. Merry Christmas.
Yeah, indeed. Merry Christmas. I think I'll write to you, but nevertheless, because we have now